everyone. How y'all doing today? Please come in, come in, come in, come in. We're gonna get you talking about this case. Um, Everyone that's watching, hello. Can y'all drop a 1 in the chat if you can hear me just fine? We're gonna do a sound check before we get into this video. So just if you're here, please go ahead and drop a 1 in the chat. Okay, I see a 1. Thank you, Miss Rhonda. How are you? Hi, Miss Linda, 2021. Hi, how y'all doing? How y'all doing? Thank y'all so much for letting me know you can hear me. So I hope everybody is doing good today. I hope everybody enjoyed their Mother's Day. I truly enjoyed mine. So I'm hoping everybody had a good day yesterday, a good day today. And we're going to get into this video. How y'all doing? How y'all doing? Hi, Renee. Hi, Miss Linda. Hi, Rugby. Hi, Rhonda Western. How y'all doing? So, y'all, we ain't going to hold up. Everybody come in. They're going to have to catch the replay. We're going to get straight into it. The video is going to be in regards to the court case with Maurice Scott on and the content creator. It's been going on for some time now. And this is their fourth amended complaint, and OWN has responded, and that is going to be the motion we go over today. We're going to go over OWN's motion today. So there is no confusion. I just want to show everybody that I did get this document straight off of Alicourt. This motion is 27 pages long. It's circled up there in the first red circle. Just so I won't be accused of spreading any misinformation, I'm going to be reading straight from the document. As you can see, it was electronically filed today on May 12, 2025. It is 27 pages, and it is a motion to dismiss from OWN. So this is OWN's motion to dismiss, and I also have it circled down at the bottom that this is a copyrighted website for Alicourt. So this is the official website that I got these documents off of. Yeah, I have to just put that out there because if you don't know, we've been accused of spreading misinformation. So to clear that up, I want to say that all the information is, of course, alleged, but I did get these documents straight off of the website. So if anything, if Alicourt is misinformed, you guys need to take that up with them. Okay? Because we're going to read these straight from the horse's mouth, basically. Now, let me add the documents. They will be on the screen. And again, we can see that it was electronically filed today. Let me readjust myself, you guys. I'm sorry. So I can see them. Give me 1 second, y'all. I want to make them a little bigger. Can I do that? It's already on full screen. I guess I can't, you guys. I'm trying to zoom in even more, but I can't. Okay, so it looks like they're not going to let me make it any bigger. So, you guys, I do have this on full screen on my end. So if you come in, I'm not going to be able to see the comments while I read it because, okay, I can zoom in that way, but it still blocks out my comment section. So I'm not going to see any comments, you guys. We're going to get into it. Really said they should request a refund at this point. Wasting people's time and resources. Yeah. So you guys, I'm gonna get to y'all comments. If you come in and you speak to me, hi everybody. I just can't see the comments because I have the documents on full screen, but we're gonna get into it after we read these documents, okay? So again, I'm sorry, I'm repeating myself. Electronically filed today in the Circuit Court of Madison County. We see it says Maurice J. Scott listed as the plaintiff. The content creator is listed as the defendant. And it is titled, it says, Defendant Oprah Winfrey Network, LLC's motion to dismiss Helen's Griffin Fourth amended cross-claim with prejudice. Let me remove Really's comment, you guys. Hi, really. Thank you for your comment. Let me just take that down so we can get into it. All right, there we go. So it says, third-party defendant Oprah Winfrey Network, LLC, known as OWN, moves to dismiss all claims against it with prejudice under Alabama Rule of Civil Procedure 12b-6 for failure to state a claim upon which relief can be granted. Griffin's claims, like her first 3 complaints, fail to withstand scrutiny. Because they fail to state a claim and have done so continuously, despite repeated amendments, Griffin's cross claim should be dismissed with prejudice. Background: Griffin's 23 claims against OWN have been dismissed 3 times. And it says, sees the documents, and it lists the documents which you can check to see that her claims have been previously dismissed 3 separate times. It says, yet Griffin, without amending her complaint in any material respect, asserts the same 23 claims again without substantial justification. Griffin's present 4th amended cross claim against OWN is again based solely on the allegations that Scott engaged in actionable misconduct by issuing subpoenas to third parties to determine Griffin's identity for the purpose of substituting her for a fictitious party in this litigation. Griffin asserts a material identical version of her prior dismissed claims supported only by legal conclusions. A variety of conclusory allegations with no demonstrated factual basis, and other conclusory allegations that lack a good faith basis and are directly contrary to what the record shows. For example, Griffin concludes that all of Scott's alleged misconducts in his personal litigation must have taken place while Scott was an employee of OWN, because Scott's entire daily life is OWN's work product, and that OWN must have had Scott file the action as OWN's attorney. But she did not plead any facts to establish that Scott's actions were in fact on behalf of OWN or in furtherance of OWN's business. Scott is OWN's attorney. While stated as fact, Griffin again includes extensive detailed speculation as to why Scott filed his lawsuit. She concludes that it must be a conspiracy between Scott and OWN, where OWN's sole goal is to lure Griffin out of her safe place. Yet, while Griffin's theories and perceptions of why Scott filed his lawsuit have evolved, motions behind Scott's lawsuit in his individual capacity still do not create a basis for the civil cause of action provided here against OWN. Okay, y'all can barely see. Hold on. In star, I can't see what that says. It says Griffin has again pled no facts providing a basis for the claims that Scott's alleged misconduct was committed in the scope of an agency or an employment relationship with OWN. Hold on, you guys. Okay, I zoomed in the other way, y'all. I'm sorry. So it say, in sum, I'm going to read that again. In sum, Griffin has again pled no facts providing a basis for the claim that Scott alleged misconduct was committed in the scope of any agency or employment relationship with OWN. Griffin also did not plead a single fact to support her allegations that OWN individually committed tortious or unlawful acts causing harm to Griffin. Standard of review. Why is it showing slide on here, y'all? Maybe I have to zoom all the way out. Yeah, there we go. Standard of review. A motion to dismiss under Rule 12b-6 challenges the legal sufficiency of a complaint. The process for analyzing such a legal challenge can be summarized as follows. When the trial court is called upon to consider Rule 12b-6 motion, it must examine the allegations in the complaint and construe it is so as to resolve all doubts concerning its sufficiency in favor of the claimant. In so doing, the court does not consider whether the claimant will ultimately prevail, only whether he has stated a claim under which he may possibly prevail. Argument. Claims are due to be dismissed with prejudice. So they are asking that this time it be dismissed with prejudice because, again, this is the fourth time of them trying to bring on back onto the case. They have been dismissed 3 prior times. And it says Griffin has failed to state a claim upon which relief can be granted against OWN for respondent superior or vicarious liability because she failed to allege any facts demonstrating, 1, that Scott is an agent or employee of OWN, or 2, that any misconduct of Scott occurred in the scope of that relationship. It is beyond doubt that Griffin can prove no set of facts, based on those asserted within the four corners of her cross claim, in support of a theory of vicarious liability that would entitle her to relief against OWN for any of the alleged misconduct of Scott. This is because a general rule, an employer or principal incurs vicarious liability to third parties only for the act of an employee that are performed within the scope of the employment, or for the acts of an agent that are performed within the scope of an agency. And it lists a court case. Griffin has again failed to plead facts demonstrating that Scott's alleged misconduct took place within the scope of employment or agency relationship. In the context of an employment relationship, the common law doctrine of respondent superior governs vicarious liability. And this is another court case. To recover against a defendant under the theory of respondent superior, it is necessary for the plaintiff to establish the status of employer and employee. The law in Alabama is well settled that an employer is not liable for the intentional acts of its employee unless the acts were committed within the scope of the employee's employment or were done to further the interests of the employer. As an employer, it is not liable under the doctrine of respondent superior when the employee acts for his or her own personal gain and not in the furtherance of the employer's business. The doctrine of respondent superior does not hold employers liable for acts imply. Hold on, y'all. Lord, I got to keep zooming in and zooming out, y'all. Excuse me. For the acts impelled. No, you didn't just start over. Okay. Impelled by its employees' motives that had nothing to do with the employee's duties of his employer. That is true even if the employee's independent pursuits happen to confer in the unintended or identical benefits of his employer. Here, Griffin has two burdens. First, she must plead facts sufficient to show a status of employer and employee between Scott and OWN. Second, she must plead facts demonstrating that Scott's actions were done within the scope of the employee's employment. Griffin has accomplished neither. In her cross claim, Griffin pled that Scott is a cast member of the show Love and Marriage Huntsville, which appears on the Oprah Winfrey Network. He must be an employee. The only fact pled in support of the legal conclusion that Scott is an employee, agent, or servant of OWN's is that he is a cast member on a single television program that airs on OWN. She further pled that since Scott is an attorney licensed in the state of Alabama and appears on the show that airs on Oprah Winfrey Network, then he, therefore, is OWN's attorney and agent. Even if that was sufficient to plead an employment relationship between Scott and OWN, there is no single factual allegation in Griffin's cross-claim to show that Scott was acting in the scope of such employment where he bought, identified, and began prosecuting his fictitious party lawsuit against OWN. The same is true. The same is true for a principal-agent relationship. She alleges no facts that show Scott was acting on OWN's behalf when she alleged misconduct took place, or was otherwise acting within the scope of an agency relationship. There are no facts demonstrating that any alleged misconduct by Scott was committed in the line and scope of an employment and agency relationship with OWN, or that there were committed in furtherance of OWN's business interests. Instead, Griffin fills her amended cross-claim with unsupported conclusory statements. Griffin claims that since Scott appears on the program that airs on OWN Network, nothing personal remains of Scott, and OWN directs and controls Scott is his entirety. She contends that Scott's entire personhood is inseparable from OWN and that Scott's existence owns works, products. Griffin has pled that Scott's entire life and anything he does is within the scope of an employment or agency relationship with OWN. No facts in the cross claim support this conclusion. The legal complaint brought by plaintiff Maurice Scott was drafted and filed by him alone and in an individual capacity in furtherance of his individual legal rights. And they say, see document. And it says the litigation has never appeared on a program aired by OWN. Tellingly, Griffin has not and cannot direct this court to a single episode to establish otherwise. Griffin hints to this reality by her continued speculative conclusions that the litigation's was own attempt to create a new, hold on y'all know I gotta zoom in and out. That this litigation was OWN's attempt to create a new future storyline. She believes this will be a deadly storyline where one cast member pressures and lures Griffin into the public from her safe space, and the other cast member shoots her. I'm surprised by that, y'all. I didn't know she said that. She said, at its best, her claim that OWN is involved in Scott's alleged misconduct because OWN is planning to use it as some kind of storyline is premature. At its worst, it is a false pleading with no good faith basis or substantial justification in violation of Rule 11, obligations under the Alabama Rule of Civil Procedure. Griffin failed to plead facts establishing that Scott's alleged misconduct was committed in the scope of an employment or agency relationship with OWN, or was undertaken in furtherance of the business of OWN as required to hold an employee or principal vicariously liable for the acts of an employee or agent in Alabama. Scott's civil complaint against Griffin and his actions taken to identify and serve her was his complaint is in pursuit of his individual rights and remedies under the law, entirely separate from the network on which an unscripted program he appears upon airs. Nothing in Griffin's cross claim, as amended, establishes otherwise. The claim against OWN are due to be dismissed because Griffin has failed to plead a set of facts in support of claims that would entitle her to relief against OWN. Part 3 says Griffin has failed to state a claim upon which relief can be granted against OWN for Scott's alleged misconduct because the predicate acts for her claims are protected under the litigation privilege. Griffin's cross claim also fails because the predicate misconduct forming this entire basis of all 23 claims is protected under Alabama's absolute litigation privilege. As such, Griffin has not stated a claim against OWN that would entitle her to relief. Um, Mercy said, what's happening? We are currently reading OWN's motion to dismiss the content creator's fourth amended complaint. So OWN was dismissed from the case 3 times before this, and now they filed a fourth amended complaint. So this is OWN's response, and they are now asking for it to be dismissed with prejudice. Okay. Were the allegations in the complaint established by the defendant's conduct occurred under circumstances that amounted to a privileged setting? Statements made in this course of litigation by a party are protected under the litigation privilege, such as that the statements cannot be made the basis of civil liability. And then it lists some court cases to back up what they just said. And it says the Alabama absolute litigation privilege can prevent a plaintiff from stating a claim against a defendant for invasion of privacy based on the defendant's pursuit of litigation against him. Taylor v. Midland. And it says holding that Alabama's absolute litigation privilege bars the plaintiff invasion of privacy claim to the extent the claim was based on defendant's pursuit of the underlying collection litigation. In the Taylor case, the plaintiff argued that absolute litigation privilege did not apply because the basis for his invasion of privacy claims was not any particular statement that the defendant made during the course of the underlying litigation, a collection action, but rather their act of pursuing the collection action itself, applying Alabama law as set forth. And it gives us some more cases to back up what they said. Okay. It says that Alabama absolute litigation privilege barred the plaintiff's invasion of privacy claim to be to the extent the claim was based on the defendant's pursuit of the underlying collection litigation. Here, it is not Scott's act of issuing subpoenas alone that forms the basis of Griffin's cross claim. It is that the statement made within the subpoena, Ducis Tecum's, and the information elicited by such statements that Griffin take issue with and deems torturous. Alabama absolute litigation privilege bars Griffin from basing her civil action on the subpoenas from this litigation and the statement made within them. Griffin's sole basis for each of her claims against OWN is Scott's conduct is drafting and issuing of subpoenas that she calls Rule 45 fraud. Because Scott's pursuits and furtherance of the underlying litigation through the subpoenas at issues is absolute privilege, it cannot form a basis for a civil action. On this basis, the cross-claim is due to be dismissed in its entirety. Even if the cross-claim was formed on a proper basis, Griffin failed to state a claim against OWN individually because she pled no facts demonstrating that OWN individually committed any torturous act. In each of her 23 counts levied against Scott and OWN, Griffin asserts the parties are individually, jointly, and severely liable. Taking the factual allegation as true and viewing them most strongly in the pleader's favor, Griffin asserts no facts that OWN individually engaged in any of the torturous or otherwise wrongful or illegal conduct. Parsing out the conclusory allegation and legal conclusion to the extent the factual allegation asserted by Griffin establishes that 1, OWN airs an unscripted program, Love and Marriage Huntsville. 2, Scott appears on the show aired by OWN. And 3, Griffin, among others, watched the show. These 3 elementary facts, paired with the blanket declaration included with each count stating OWN has ratified Scott at all times relevant. OWN has acted through Scott or acted alone at all times relevant. And that the unsupported speculatory conclusions zoom in. I know, y'all. I told you I got to zoom in and out. Move. Okay, so these documents just don't want to do right for me today. The conclusions are insufficient to state a claim against OWN individually upon which relief can be granted. Apart from the 3 facts above, Griffin does not state any other specific facts regarding OWN. Instead, she has amended her cross-claim to include a slew of conclusory allegations and legal conclusions in an attempt to state a claim against OWN. Individually, for example, she pled that Scott is OWN's network's product and intellectual property, and that Scott has no capacity beyond OWN, and therefore OWN is individually liable for his actions. How Scott's personhood has been erased such that no individual capacity exists remains unknown to any reader of the cross-claim. Griffin pled no facts establishing a basis for the conclusion that OWN has coached Scott's conduct, or that OWN was even aware of Scott's conduct in his personal litigation. Before being served with the present cross claim, speculating further, Griffin stated that Scott, at OWN's direction, has waived his individual rights to pursue any cause of action or seek remedies as an individual, and that Scott must have filed this lawsuit for OWN since he is a licensed attorney and appears on the show that airs on OWN. These conclusions were stated with no factual basis, and Griffin has failed again to plead facts establishing that OWN individually committed any torturous conduct against her. While her factual allegations are accepted as true, conclusory allegations, unwarranted deductions of facts, or legal conclusions masquerading as facts will not prevent dismissal. The fact Griffin has provided in no way create or support a claim that would entitle her to relief against OWN under Alabama law, because Griffin has failed to plead a set of facts in support of a single claim against OWN that would entitle her to relief against OWN individually. Griffin's 23 claims are due to be dismissed. The specific deficiencies of the 23 counts are addressed in turn in Section 5. And then it just repeats again that Griffin has failed to state a claim upon which relief can be granted against OWN because facts constituting each element of her various causes of action cannot be found by even the most liberal reading of her cross-claim. For Griffin's claim against OWN, the law is well settled that a defendant cannot be held vicariously liable for a tort when the plaintiff cannot establish underlying liability for the tort. And it lists some more court cases to support that. It says, accordingly, to state a claim upon which relief can be granted against OWN, Griffin must adequately plead each of her claims. She failed to do so. A. Counts 1, 2, 3, 4, 6, 21, 22, and 23 evasion of privacy claims. Griffin asserts a variety of invasion of privacy claims in Alabama. Invasion of privacy consists of 4 limited and distinct wrongs. 1. Intruding into the plaintiff's physical solitude or seclusion. 2. Giving publicity to private information about the plaintiff that violates ordinary decency. 3. Putting the plaintiff in a false but not necessarily defamatory position in the public eye. Or 4. Appropriating some element of the plaintiff's personality for a commercial use. And although all of the claims concern in the abstract the concept of being left alone, each tort has distinct elements and establishes a separate interest that may be invaded. In order to state an invasion of privacy claim, a plaintiff must clearly state what information defendants allegedly accessed that invaded her privacy, and more broadly, what type of invasion of privacy claims she wishes to pursue. It says here Griffin's cross-claim is based on naked assertions of fact that Scott has wrongfully attempted to access confidential, private, protected, and privileged information about Griffin based on the subpoenas he issued to PayPal Inc., Block Inc., Google LLC, and Meta Platforms Inc. Scott was allegedly seeking Griffin's most private, most private and privileged data, bank account information, and identity data. Yet she fails to plead facts demonstrating Scott was in fact wrongfully accused and did obtain private and privileged data. Griffin's pleadings merely contain allegations that Scott used subpoenas to request specific identifying information of Griffin. She did not plead that PayPal Inc., Block Inc., Google LLC, or Meta Platforms Inc. actually produced any information to Scott pursuant to the subpoenas. And if they did not make a production, what information that included, regardless, issuing a subpoena, Duces Tecum to glean information about a party in litigation is not a wrongful intrusion. Invasion of privacy in Alabama requires a wrongful intrusion into one's private activities. The tort of invasion of privacy is the wrongful intrusion into one's private activity in such a manner as to outrage or cause mental suffering, shame, or humiliation to the person of ordinary sensibilities. More court cases to support their claims, they just said. Here, Griffin has not pled a wrongful intrusion into her private activities. Instead, she pled that Scott sought information about her, such as her name and address, for this litigation pursuant to subpoenas Duces Tecum. She further did not plead a set of facts that demonstrates owns particip- She further did not plead a set of facts that demonstrates OWN participated in any manner in the filing of the subpoenas Duces Tecum. Griffin failed to plead facts showing a wrongful intrusion by OWN. Griffin also asserted an invasion of privacy through cyber stalking claim, count 6, but failed to cite any Alabama or federal law creating a private cause of action for cyber stalking. This count fails to state a claim upon which relief can be granted because Alabama has not established a civil cause of action for cyberbullying. Hold on, I'm sorry. Established a civil cause of action for cyber stalking by statute of common law. Accordingly, Griffin has failed to state a claim upon which relief can be granted for invasion of privacy, and counts 1 and 4 are due to be dismissed. In count 22, Griffin specifically claimed that OWN invaded her privacy by appropriating some element of her personality for a commercial use. Fourth Amendment, it says, to state this claim, Griffin must show that OWN appropriated Griffin's name or likeness to its advantage commercially or otherwise. Lack of consent from Griffin and resulting injury to Griffin. The Supreme Court has noted that no one has the right to object merely because his name or his appearance is brought before the public, since neither is in any way a private matter and both are open to public observation. And then it says, rather, it's only when a publicity is given for the purpose of appropriating to the defendant's benefit the commercial or other values associating with the name or the likeness that the right of privacy is invaded. Here, Griffin has not pled that OWN appropriated Griffin's name or likeness to advertise his own business or product, or for some other similar commercial purpose. Griffin did not plead facts showing she was specifically identified by name or likeness in any episode aired by OWN. Indeed, she has not cited to any such television episode in her complaint. Even if she could do so, she cannot. She has not pled that any unique quality or value in her name or likeness would result in commercial benefit to OWN. All she pled is that Maurice Scott, in the lawsuit he filed, issued subpoenas, Dusa Tecum, for select information about Griffin. She has failed to state a claim against OWN that OWN invaded her privacy by appropriating some element of her likeness for commercial use. Lastly, in count 23, Griffin claims that OWN invaded her privacy by placing her in a false position in the public eye. Under Alabama law, a party may be liable for false light invasion of privacy if the party gives publicly to a matter concerning another that places the other before the public in a false light. If A, the false light in which the other was placed would be highly offensive to a reasonable person, and B, the action, is that the action or the actor, y'all? The actor had knowledge of or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the other would be placed. A party gives publicity to a matter by showing that false and highly offensive material has been communicated to so many persons that the matter must be regarded as substantially certain to become one of public's knowledge. Here, Griffin has not pled facts demonstrating that OWN communicated false and highly offensive material regarding Griffin to anyone, based on the sole alleged misconduct of Scott issuing subpoenas dusum tecum. She has failed to state a claim against OWN that OWN invaded her privacy by placing her in a false light in the public eye. Accordingly, Griffin invasion of privacy claims fails to state a claim and are due to be dismissed. B. Count 5 and 15. Violations of Stored Communication Act, 18 U.S.C. Section 2701. First, Griffin has failed to state a claim upon which can be granted against OWN under the Stored Communication Act. Because she has failed to plead facts establishing that Scott or OWN intentionally accessed without authorization a facility through which electronic communication service is provided. Instead, Griffin has pled that Scott used subpoenas issued by the court to receive information concerning her identity. The fact that Scott used subpoenas lawfully available to him in the course of this litigation demonstrates that Griffin has not pled facts establishing access without authorization. Second, Griffin has failed to state a claim upon which relief can be granted because she has failed to plead facts establishing that Scott or OWN received access to these contents of any protected stored communications. She pled that Scott learned her identity. However, the SCA does not protect identity and contact information. It protects disclosure of stored electronic communications. Specifically, the Stored Communications Act applies to electronic communication while in electronic storage. The term electronic communication means any transfer of signs, signals, writing, images, sounds, data, and intelligence of any nature transmitted in whole or in part by wire, radio, electromagnet, photo, electronic, or photo optical system that affects interstate or foreign commerce. Here, the civil subpoenas issued by Scott, which form the basis of this misconduct alleged by Griffin, seek basic identifying information about Griffin and other named defendants, and not communication. The identities of the defendants, including Griffin, were originally unknown to Scott since they operated under anonymous YouTube and other social media account names. Scott sent subpoenas to PayPal Inc., Block Inc., Google LLC, and Meta Platforms to determine the identities and the contact information of the defendants. Because these subpoenas did not seek the contents of any stored communications associated with these accounts at issue, they do not implicate the prohibition of the stored communication. Griffin has failed to plead facts stating that Scott, on behalf of OWN or OWN individually, accessed stored communication without authorization as required to state a claim under 18 U.S.C. 2701. Counts 5 and 15 should be dismissed. And then it says count 8, tort of outrage claim. Let me see. And then, so basically, on is saying whatever y'all said Maurice not did has nothing to do with us. Yeah, basically they're saying that, and they're also saying that she's not providing a claim. She's not giving anything to back up her claims. She's not providing any real legal, argument as to these claims that she's seeking against them. Not only are they not, they're saying they're not responsible for Maurice, they're saying she's not producing any legitimate legal argument that will keep them tied to this case. Um, C is count 8, tort of outrage claim. And it says under Alabama law, the tort of outrage is the same cause of action as intentional infliction of emotional distress. The tort of outrage requires that one, the actor intend to inflict emotional distress or knew or should have known that emotional distress was likely to result from his conduct. Two, the conduct was extreme and outrageous. Three, the defendant's actions caused plaintiff distress. And four, the distress was severe. With respect to the conduct element, the court has stated that the conduct must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in civilized society. So that's what the tort requires. It says the Supreme Court of Alabama has characterized the tort of outrage as an extremely limited cause of action where recovery is available for a few kinds of conduct. The court has recognized it in regard to limited kinds of conduct, including one, wrongful conduct in the family burial context, two, barbaric methods employed to coerce an insurance settlement, and three, egregious, Lord, I can say that, sexual harassment. Another example of conduct so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency, such that Alabama law allows relief, includes a family physician exchanging addictive prescription drugs for sex from a teenage patient, resulting in the teenage patient's addictions, resulting in the teen opiates addictions. So when the facts pled do not amount to conduct so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized society, then a trial court may dismiss the outrage claim for failure to state a claim pursuant to Alabama Rule of Civil Procedure 12B. Here, in stating her claim under Alabama Rule of Civil Procedure 8A, Griffin must not only provide a short and plain statement of her claim, she must also show that she is entitled to relief. Even if all the allegations Griffin cite in support of her tort of outrage and intentional infliction of emotion distress claims are true, the facts are personally insufficient to rise to the outrageous level necessary to support such claims. The facts do not rise. Let me let this down. The facts do not rise to the level at which Alabama courts have allowed recovery of the tort of outrage, i.e., cases involving misconduct in an improper burial, sexual harassment of assault, barbaric methods of coercion against an insurance settlement. So 3D at 1240 affirming the trial court's dismissal of the plaintiff's outrage claim when the defendant's conduct improperly causing the plaintiff's termination and subjecting the plaintiff to severe emotional distress did not rise to the level of conduct where relief should be granted. Griffin has alleged that Scott wrongfully bought, identified, and is prosecuting a fictitious party lawsuit against Griffin, and that he issued subpoenas duces tecum to discover her identity. That conduct is not so extreme and outrageous, such that it has caused emotional distress. So severe that no reasonable person could be expected to endure it. Instead, it is lawful conduct that is authorized and sanctioned by our Alabama rules of civil procedure. Accordingly, Griffin has not pled facts sufficient to establish a plausible claim for intentional infliction of emotional distress or outrage, and these claims are due to be dismissed. D. Count 9. Negligence per se. Griffin's negligence per se claim relies in part upon statutory violations asserted in all other claims, which are themselves deficiently pled as explained in the above and below sections. This claim is due to be dismissed because Griffin has failed to plead claims under any cited statute upon which relief can be granted and articulated in sections A through C above and E through K below. She further alleges that OWN is liable for negligence per se in lights of Rule 502 and 503 of the Alabama Rules of Evidence, which pertain to privilege, Fourth Amendment. However, Griffin has neither pled facts demonstrating that OWN has introduced evidence in violation of Rule 502 and 503 of the Alabama Rules of Evidence, not stated a cognizable claim for which relief based on an alleged violation of the rule of evidence. Count 9 is due to be dismissed. E. Count 10. Conversion. In count 10, Griffin pled that Scott and OWN converted some of his personal information. Really? In count 10, Griffin pled that Scott and OWN converted some of her personal information maintained by third parties in an effort to identify her for purposes of filing the lawsuit. The personal information was obtained by subpoenas issued by the trial court, and it lists some documents for the court to look at. To state a claim for conversion under Alabama law, there must be 1, a wrongful taking, 2, an illegal assertion of ownership, 3, an illegal use or misuse of another's property, 4, a wrongful detention or interference with another's property. A plaintiff claiming conversion must establish that the defendant converted specific personal property to his own use and beneficial enjoyment, or that the defendant destroyed or exercised dominion over property to which, at the time of the conversion, the plaintiff had a general or specific title, and of which the plaintiff was in actual possession, or to which he was entitled to immediate possessions. Here, Griffin has failed to state a claim upon which relief can be granted because she has not pled facts demonstrating a wrongful or illegal taking by own. Instead, what is that? Instead, she has pled that Scott used the subpoenas issued by the trial court to obtain the information. It is not wrongful or illegal taking for a party to use the Alabama rules of civil procedure to advance his lawsuit and identify fictitious parties' identities. Further, Griffin has failed to plead facts establishing that she are we on the right page? Let's see. Yeah, Griffin has failed to plead facts establishing that she had general or specific title of the information in question. Instead, she pled that the information was in the possession of a third party. Hold on, y'all know I'm zooming in and out here. Oh, I didn't know these documents was gonna be this hard. They usually be clear. I guess I didn't make them big enough when I added them to StreamYard. Okay. Griffin also pled no facts indicating that the alleged conversion of her identifying information by Scott was done for the benefit of OWN or in furtherance of OWN's interest. And no facts were pled indicating that OWN authorized or participated in conversion or later ratified the conduct so as to give rise to any direct liability for conversion. Griffin has failed to state a claim upon which relief can be granted against OWN for conversion, and this claim is due to be dismissed. So they just chopping everything down, y'all. They just saying everything needs to be dismissed. Counts 11, 12, and 13, negligence, gross negligence, and negligent supervision and hiring claim. Griffin's claims against OWN or negligence are due to be dismissed because, as pleaded, Griffin did not plead facts establishing two elements of the negligence claims: that OWN owned a duty to Griffin or that OWN breached that duty. Further, Griffin did not plead that OWN had any notice or knowledge of any incompetency in Scott. As to the negligent hiring claim under Alabama law, negligent supervision and hiring claim necessarily involves the employer disregarding a known incompetency or unfitness in the employee. And then let's see. The essential elements of the claim that Griffin must have pled to establish negligent hiring, training, or supervision claims are: 1, the employer hired, tainted, or supervised an employee with an incompetency. 2, the employer knew of the incompetency or would have learned of it. By exercising due care. And 3, the employee caused the plaintiff harm due to the incompetency. Griffin has failed to state a claim upon which relief can be granted under Alabama law because there is no Alabama authority establishing a duty flowing from a television broadcaster to a member of the general broadcast audience concerning the cast members it hires and or supervises. Griffin has not and cannot cite one Alabama case that has recognized a duty to a member of the general viewing public on behalf of the broadcaster when it comes to the talent it hires to be on air. In addition to duty, Griffin failed to adequately plead that OWN breached a duty owed to Griffin. The Alabama Supreme Court has held that the master is responsible for his servant's incompetency when notice or knowledge, either actual or presumed, of such unfitness has been brought to him. Griffin has failed to plead facts establishing that OWN had prior knowledge of Scott engaging in similar conduct against others in the viewing audience. There are no facts alleged in the cross claim to establish that Scott engaged in similar conduct with any other fans or members of the Love and Marriage Huntsville viewing audience outside of the current lawsuit that he has filed. In short, no facts demonstrate that OWN had prior notice of Scott's alleged vindictive nature, and OWN has breached a duty, if one were to exist, owed to Griffin. Because Griffin failed to plead facts establishing the essential elements of the negligent hiring, training, or supervision claims against OWN, these claims are due to be dismissed. Okay. Then it goes on. G. Count 14, wantoness. Count 14, a claim of wantoness against OWN is due to be dismissed because Griffin failed to plead facts demonstrating a wrongful act that proximately caused her injury. To establish wantoness under Alabama law, the plaintiff must prove that the defendant, with reckless indifference to the consequences and consciously and intentionally, did some wrongful act or omitted some known duty. To be actionable, the act or omission must proximate causes the injury which the plaintiff complains. Here, Griffin has pled facts establishing that Scott filed a defamation lawsuit against her. What is that? Scott used the subpoena power of the court to learn her identity through issuing subpoenas, duces tecum, to non-parties, and that she has been injured by having to defend herself in the lawsuit. It is not an illegal or wrongful act to file a lawsuit against an individual for defamation. It is not an illegal or wrongful act to issue a subpoena, duces tecum, to learn the identity of a fictitious party, known only to the plaintiff by an anonymous YouTube username. Griffin has failed to state a claim upon which relief can be granted because the facts pled do not demonstrate illegal or wrongful conduct, or that OWN even engaged in that conduct. H. Count 16 and 17, constitutional claims. Griffin alleges that when Scott issued non-party subpoenas, OWN violated her freedom of speech and assembly in violations of the First and 14th Amendment of the United States Constitution. She further alleges that when Scott issued non-party subpoenas, OWN violated her inalienable right to life, liberty, and pursuit of happiness under Sections 1 of the Alabama Constitution. To claim a violation of the federal or state constitution, a plaintiff must allege State action. A private entity can qualify as a state actor in a few limited circumstances, including, for example, when the private entity performs a traditional exclusive public function, when the government compels the private entity to take a particular action, when the government acts jointly with the private entity. Here, Griffin did not allege that any of the alleged constitutional violations were conducted by a state actor. She did not assert that OWN is a government agency. She has not plausible pled that OWN performs a function that is traditionally the exclusive prerogative of the state, or that there is sufficiently close nexus between the state and the private entity, such that the private entity actions can be fairly treated as those of the state itself. She did not plead facts that would meet any of the three tests cited in the Manhattan Community Access, such that would qualify as a state actor. Because the cross claim identified no state action or actor, counts 16 and 17 against OWN are due to be dismissed. Count 18, claims for restraining order under Alabama rule of Civil Procedure 65. The injunctive relief and or temporary or permanent restraining order requested by Griffin in court 21 is a remedy, not an independent cause of action. For the reasons stated in the motion, Griffin has failed to state a claim against OWN upon which relief could be granted, including injunctive relief. Count 18 is due to be dismissed as a consequence of dismissal of all previous claims. J. Court, I'm sorry, count 19, Alabama right of publicity claim. Griffin claims that OWN is liable under Alabama Right of Publicity Act for accessing her identity. Through subpoenas in this litigation and allegedly airing Griffin's and indicia of identity to tamper with Griffin as a witness. Hold on, y'all. I'm zooming in. Let me take it off full screen. Lord Jesus. Okay. I'm sure y'all can see it, y'all, but I cannot see it on my end. It is not big enough. Okay. To tamper with Griffin as a witness of a criminal proceeding in or a pending criminal litigation / investigation. The Alabama Right of Publicity Act provides that any person or entity who uses or causes the use of indicia or identity of a person or of a products of good, merchandise, or services entered into commerce in the state, or for the purpose of advertising or selling or soliciting purchases of the products, good, merchandise, service, or for the purpose of fundraising or solicitation of donations and for false endorsement without consent, shall be liable under the Act of Alabama Code 6-5-722. First OWN has issued no subpoenas in this litigation. Maurice Scott did. Scott does not represent OWN in this litigation, only himself. Griffin only alleges that Scott issued subpoenas requesting certain information, but fails to allege facts establishing that Google, other subpoena parties, actually provided any information to Scott. Second, while Griffin speculates that OWN allowed the airing of Griffin's indicia of identity, she failed to cite any specific instance where OWN aired a single mention of Griffin. Even if OWN had aired an episode of Love and Marriage Huntsville where a cast member mentioned Griffin names, it did not. Griffin still did not plead facts establishing that Griffin's identity was used in products, goods, merchandise, or services entered into the commerce in this state, or for the purpose of advertising or selling or soliciting purchases of products, good, merchandise, or services. Go back. For purpose of fundraising or soliciting of donations or for false endorsement. Griffin pled no facts demonstrating that OWN used Griffin's identity to advertise or sell a product, good, merchandise, or service. The totality of Griffin's facts failed to state a claim upon which relief can be granted against OWN under the Alabama Right of Publicity Act, and the count due to be dismissed. K. Count 7 and 20, doxing and invasion of privacy by tampering with a witness. A new flair to the fact added for the first time in Griffin's third amended complaint and asserted again in the fourth complaint is that the subpoenas issued by Scott in this litigation were actually used in conspiracy with OWN in an attempt to tamper with Griffin as a witness and victim of an alleged crime. She contends that this case of action exists under Alabama Code Section 13A-10-124. This provision of Alabama's criminal code provides that a person commits the crime of tampering with a witness if he attempts to induce a witness or a person he believes will be called as a witness in any official proceeding to, 1, testify falsely or unlawfully withhold testimony, 2, absent himself from any officially proceedings to which he has been legally summoned. Alabama Code 13A, this code establishes a misdemeanor. This section from the criminal code does not create or establish a private civil cause of action. Griffin has no private cause of action for witness tampering against OWN. Furthermore, she provides no case number for this alleged criminal proceeding, pled no facts demonstrating that OWN attempted to induce a witness to testify falsely or withhold testimony, and did not identify any actions that OWN took individually to tamper with a witness. She only alleged that Scott had subpoena ducis tecum issued from the court in this litigation. Similarly, Griffin alleges that OWN is liable for doxing. She contends that this is a case of action arising under Alabama Code Section 13A-11-38, which provides that an individual commits the crime of doxing if she or he intentionally electronically publishes, posts, or provides personal identifying information of another individual, which the intent of the others will use that information to harass or harm the other individual, and the other individual is actually harassed or harmed. This claim fails for two reasons. First, Griffin has failed to state a claim for which doxing, because this criminal code section does not create or establish a private civil cause of action. Alabama Code 13A-11-38. Second, she has not pled facts demonstrating that OWN published, posted, or provided her personal identifying information to anyone. Griffin further failed to plead facts establishing that she was harassed or harmed as a result of a publishing of this personal identifying information by OWN. Count 7 and Count 20 failed to state a claim against OWN and are due to be dismissed. OWN expressly reserves its right to move by a separate motion for attorney fees and costs pursuant to the Alabama Litigation Accountability Act because Griffin's fourth amended cross-claim complaint and her prior complaints were brought without substantial justification and asserts claims groundless in the law of fact. Conclusion. With her claims, Griffin is grasping at meritless theories in response to her unfortunate litigation with Maurice Scott. She, litigation with Maurice Scott, and his individual use of subpoenas to glean information regarding her. These claims do not entitle Griffin to relief from OWN. Griffin should not be permitted to proceed on her frivolous claims. OWN, therefore, respectfully requests that the court grants its motion to dismiss all 23 claims with prejudice, dated May 12th, 2025. So basically, they wrapped that on up. So that paragraph from the conclusion makes me think that they may possibly file another motion and seek to get their attorney fees returned to them. Because, as mentioned, this is her fourth time trying to come back and add on this lawsuit. So they've had to pay their attorneys 4 different times to file these motions to dismiss, and they all have been granted. This is the fourth one. We'll see what the judge rules on this. And then in conclusion, they basically called her claims frivolous and, said she shouldn't be permitted to proceed. I know they're getting tired of basically keep having to file the same motion. They basically said in this motion that, she keeps submitting the same claims, but she's not giving them anything to issue her any relief on. So we shall see what the judge thinks about this fourth amended complaint and what the judge is going to have to say, whether he just dismisses it or he actually dismisses it with prejudice so they cannot just amend the complaint and come back and file a fifth complaint. I think this case has been going on for over a year now, and this is the fourth complaint. So I'm kind of sick of it at this point. That's what I'm gathering from this last motion they submitted. They're kind of getting tired of these amended complaints being added to the court and them having to take time, pay attorneys, and submit a dismissal motion. So once the judge issues that dismissal, I will let you guys know and I will keep y'all updated. What do y'all think about all this? It was a long 27 pages, y'all. But I wanted to read it because it looks like OWN is kind of getting fed up with this whole case. And they basically, in my opinion, are saying, look, your beef is with Maurice Scott. That has nothing to do with us. You need to be trying to go after him for whatever you're claiming he did. He did not sue you guys on our behalf. We have nothing to do with what he is suing you for. Basically, like, take that up with him. Keep us out of it. We got dismissed 3 times prior to this, and that's how they want to keep it. OWN does not want to be involved in this lawsuit. In my opinion, they will be dismissed again. They've gotten dismissed several times before this motion. So I think the judge is going to dismiss them again, whether or not the judge does it with prejudice so they cannot file another amended complaint. We're going to have to wait and see. So y'all hit the like button for me. Drop down in the comments. Let me know what y'all think about all this. I'm going to go ahead and end this live here. Y'all have a good day.